Welcome to my channel, Legal Jargon. In my channel, I discuss law-related concepts and other current affairs updates relevant for cracking judicial services exams and other competitive exams. Please like and subscribe my channel and hit on the notification button for further updates. In today's session, I would be discussing the topic of charge covered under the Code of Criminal Procedure. Definition of charge is covered under Section 2, subsection B of the Code of Criminal Procedure. Charge is defined as any head of charge when the charge contains more heads than one. It is a specific allegation which is framed by the court where the accused is called upon to answer the allegation. The provisions dealing with charges are covered from Section 211 to 223 of the Code of Criminal Procedure. They can be classified as follows. From Section 211 to 214, the contents and particulars of charges are described. Section 216 deals with the alteration of charge. Section 218 to Section 222 deals with the joinder of parties, and Section 223 specifies the joinder of offenders. Contents of a charge are covered under Section 211 of the Code of Criminal Procedure. The contents of a charge contain the following: the offence with which the accused is charged. For example, the accused can be charged under Section 299 and Section 300 of the Code of Criminal Procedure. The specific name of the offence described in the charge. So, Section 299 deals with culpable homicide and Section 300 deals with murder. These are specific names of the offence which have to be included in the charge. The definition of the offence has to be included in the charge as per law. So, the definition of culpable homicide and murder as given under the Code of Criminal Procedure have to be included in the framing of the charge. The law against which the offence has been committed. Every legal condition has to be fulfilled before the judge can frame a charge. So the legal conditions of culpable homicide and murder have to be fulfilled before the judge can frame a charge. It has to be written. The charge has to be written in the language of the court, and any previous conviction regarding any other offence or the same offence can be added to the charge for enhanced punishment. For example, if a previous murder had been committed or a previous instance of culpable homicide has also taken place for which the accused has been convicted, that can be added for enhanced punishment in the current charge. 212 explains the particulars to be stated in a charge. The following are the particulars: time and place of the alleged offence, against whom or which thing in respect of which the offence has been committed. It is reasonably sufficient to give accused notice of the matter with which he is charged. Accused is charged with criminal breach of trust or dishonest misappropriation of property. In such case, the particulars that have to be stated is the gross sum or movable property that has been used in the offence and the dates between the offence has alleged to have dates between which the offence has alleged to have been committed. Also, the time included between the first and the last date shall not exceed 1 year when the particulars are stated. Section 213 deals with the manner in which the offence is committed. When Section 211 and Section 212 do not give the accused sufficient notice of the offence committed, then under Section 213 a sufficient notice is given to the accused by stating the manner in which the offence is committed. Section 214 states the words describing an offence with the sense attached to under law. Section 215 deals with the effect of errors. No error in stating an offence can be used to set aside a conviction of an accused person unless it is so material in nature that it occasions a failure of justice or causes prejudice to the accused person. Section 216 deals with alteration of charges. Alteration or addition of charges can take place only before the judgment is pronounced. The altered charges have to be read and explained to the accused. The court shall proceed with trial as if the alteration or addition of charges has taken place to the original charge. This section does not affect the operability of Section 71 of the Indian Penal Code, which deals with several acts. When one or more of such acts by itself would constitute an offence and constitute when combined a different offence, then such acts will be tried and charged in one trial. charged and tried in one trial. For example, if X is hurting Y and Z comes in between to save Y, and X gives an intentional blow to Y, then X will be liable for causing hurt to Y and causing a blow to Z. Once an alteration or addition of charge takes place and it causes prejudice to the accused person, then the court will order a fresh trial. After alteration or addition of charges, the court can recall or re-examine any witness based on the altered charge or summon for further examination of witnesses. The order of charges is covered from section 218 to 222. Section 218 in short deals with separate charges, section 219 with the same kind of offences, section 220 with offences falling within the same transaction, section 221 when offences are doubtful in nature, section 222 with offences that are proved. Section 218 deals with separate charges. Section 218 states that for every distinct offence there will be a separate charge. An application shall be made in writing by the accused to the magistrate, and the magistrate, without causing prejudice to the accused, may try together all or any number of the charges framed against such person. Section 218 does not affect the operation of Section 219, Section 220, Section 221 and Section 223. An illustration under Section 218 is that when A is accused of theft on one occasion and of causing grievous hurt on another occasion, A must be separately charged and separately tried for theft and for causing grievous hurt. Section 219 deals with three offences of the same kind. When the accused has committed more offences than one within a time span of 12 months, then he will be tried at one trial for the same kind of offences not exceeding 3. Offences of the same kind are those offences which are punishable with the same amount of punishment falling under the Indian Penal Code or under any special or local law. For example, an offence punishable under Section 379 of Indian Penal Code that deals with theft and Section 380 of Indian Penal Code which deals with theft in a dwelling house are same kind of offences and can be punishable in one trial if committed within a span of 12 months. Section 220 deals with offences falling within the same transaction. When there are a series of acts forming the same transaction and there are more offences than one committed by the same person against one or more persons, then such person will be tried at one trial for one or more of such offences. For example, when a person has committed an offence of dishonest misappropriation of property or criminal breach of trust or concealment of such offence or offences or one or more offences of falsification of accounts within the same transaction, then he will be charged with at one trial for every such offence. Another example which can be used to understand Section 220 is that when A rescues B from lawful custody and in the process causes grievous hurt to C, who is a constable, then A will be charged in one trial with offences under Section 225 and Section 333 of the Indian Penal Code. Section 225 deals with resistance to lawful obstruction to a public servant, and Section 333 deals with voluntary causing grievous hurt to deter a public servant from exercising his lawful duties. Also deals with offences having two or more definitions. When the accused person is charged with such an offence which has two or more definitions, then he will be charged at one trial for every such offence. For example, A wrongfully strikes B with a cane. A may be separately charged and convicted under Section 352, punishment for assault or criminal force otherwise on grave provocation, as well as Section 323, that deals with punishment for voluntary causing hurt under the Indian Penal Code. Section 220 also covers offences where the accused is charged with one or more of such acts which would by itself constitute an offence, and when combined a different offence. He will be charged in one trial for every such offence. We can understand this by an illustration. A commits robbery on B and in doing so voluntarily causes hurt to him. A may be separately charged with and convicted of offences falling under section 323, that is punishment for voluntary causing hurt, 392, punishment for committing robbery, and section 394, voluntary causing hurt while committing of robbery. Section 394 is a combined offence of causing hurt as well as robbery. Nothing in this section shall affect the operation of section 71 of the Indian Penal Code that deals with the limitation of punishments of an offence that is made up of several offences. 221 deals with offences which are doubtful of having been committed. When there is a single act or series of acts, from its nature it's doubtful which of several offences the fact proved will constitute, the accused may be charged with committing all or any of such offences. So any number of charges may be tried at once, and it may be charged an alternative of committing one of such offence. For example, if A is accused of an act amounting to theft, receiving stolen property, or criminal breach of trust or cheating, he may be tried and charged with theft, receiving stolen property, criminal breach of trust and cheating at one trial, or be charged with committing theft or receiving stolen property or criminal breach of trust or cheating. Section 221, the accused can be convicted of an offence for what he is not charged with. Based on the evidence and circumstances before the court, if the court comes to a conclusion that the accused has convicted a different offence from what he is charged with, then the court can convict the accused for such offence without charging the accused. For example, A is only charged with theft, but it appears from the evidence that he has committed criminal breach of trust or receiving of stolen property. Then he may be convicted of criminal breach of trust or receiving of stolen property even though there is no charge framed against him. 222 deals with offences proved included in the offence charged. When an offence consists of several particulars and a minor offence has been proved and the remaining particulars have not been proved, the accused will be convicted of the minor offence even though he is not charged with it. For example, if A is convicted under section 407 for committing criminal breach of trust in respect of property entrusted to him as a carrier, but based on the circumstances it is proved that he has committed a minor offence of criminal breach of trust not entrusted to him as a carrier under section 406, then he will be convicted of such an offence falling under section 406 even though he is not charged with it. Under section 222, a person is charged with an offence, he can be convicted for attempt even though he is not separately charged with it. No conviction for a minor offence can take place when conditions requisite for initiation of such proceedings are not satisfied. So when minor offence is not proved, then the person cannot be convicted of the minor offence under section 222. Joinder of offenders takes place under section 223. And upon joinder of offenders, the offenders are tried jointly in one trial. The conditions that have to be fulfilled under section 223 are for joinder of offenders are that same offence has to be committed in the course of the same transaction, accused of an offence, an abetment or attempt to commit such an offence, when such persons are accused of more than one offence of the same kind under section 219 committed jointly within 12 months time period, different offences are committed in the course of the same transaction. In such cases, there can be joinder of offenders and they will be tried at the same trial, co-jointly. Under section 223, joinder of offenders can take place with respect to offences such as theft, extortion, cheating, criminal misappropriation of property, receiving or retaining or assistance in disposal or concealment of such property, where possession is transferred by first named persons, or abetment or attempt to commit such an offence. All these offences have to fall within the same transaction and have to be committed by one or more such offenders. In such cases, joinder of offenders takes place. When the accused persons are accused of offences committed under Section 411, dishonestly receiving stolen property, and Section 414, assisting in concealment of stolen property under the Indian Penal Code, then also there can be joinder of offenders. Joinder of offenders under Section 223 is also allowed for offences falling under Chapter 12, that is, offences relating to coins and government stamps under the Indian Penal Code, relating to counterfeit coin or abetment or attempt to commit such an offence. When offences do not fall in the above mentioned categories, the magistrate or court of session can make an application in writing and, based on his satisfaction, try all persons together if persons are not prejudicially affected.